All set? All right, let's begin, please.
May it please the Court, Elizabeth Caddick for Charles Williamson. This is a statutory interpretation issue, and it involves the interpretation of a statute that was amended in 2006. And before it was finally amended, the words proposed by the legislature mimicked Section 1 and Section 2 when Section 3 was added. And initially, the word said that someone who is convicted for a first-time failure to register shall be punished by community parole supervision for life. And that was the same as Section 1 and Section 2. Section 1 applied to persons who had previously been convicted of qualifying sex offenses. Section 2 applied to people who had been previously convicted of failure to register. And then Section 3 was added, which applied to Level 2, Level 3 offenders who were convicted for the first time of failure to register. So the first and second section said, shall be punished by community supervision for life. And Section 3 initially said, shall be punished by CPSL. However, within the months between when it was first presented until the final version, it was changed to shall be subject to.
But, you know, no question, but isn't it peculiar that in, you know, another statute dealing with this, I was thinking about the 26545, I guess, right? It does actually use the word may, which doesn't use shall. I mean, for the same result that you're arguing for.
Well, clearly the legislature traditionally will say may when it's permissive and shall when it's mandatory. It doesn't always. Even when one looks at the statute this court evaluated in Pagan, these court divided into Category 1, Category 2, and Category 3 convictions. Under Category 2, it said subject to, or it said shall. It didn't say. It said that it didn't say subject to. It said that the defendant shall be sentenced except under the provisions of a certain section, subject to community parole supervision for life. And that was the category where the court had discretion. The Commonwealth could file a petition to have the person subject to or punished by community parole supervision for life, or the defendant could file a motion to have him relieved of any obligation to suffer community parole supervision for life. But use the word shall and yet continued with a permissive or a discretionary condition. So it's not a perfect analogy because it did have in parentheses, he shall be punished by community parole supervision for life except for this other section, and that's the section that said either the Commonwealth could file a petition or to impose it, or the defendant could file a petition to have him not subjected to it. So certainly, I think if you look at any of the laws any of us cited, the statutes, the legislature is never very careful. You know, it would be wonderful if may always meant permissive and shall always meant mandatory, but they don't. And they specifically, in this case, changed that. And there are a couple of rules of statutory construction that would aid this court in deciding in favor of Mr. Williamson. One is that no provision of a statute is to be read to be superfluous, and this court is to read a statute so that there is no provision that's superfluous. And if you were to read this statute the way the Commonwealth asks, then Section 2 would be superfluous. Section 2 applies to Level 2, Level 3 offenders who have had their second failure to register. They would be covered.
But if you look at it historically, Section 2 was there and Section 3 was added later, right? I mean,
right.
You could look at it from the perspective that, yes, they could have omitted, they could have removed 2 when they put 3 in.
Yes, or simply revised 2 to say exactly what 3 says.
Yes.
But they didn't. And they specifically changed punished by to subject to. The other rule of statutory construction is that any ambiguity in a statute is to go to the favor of the defendant, and that is really the strongest argument here because it is ambiguous. We know they intentionally changed the wording, and we don't know what they mean. And if you look at cases that talk about what does subject to mean, and there are some cases not on point in Massachusetts, and actually there is no case that's really clearly on point to here. As one of the cases the defendant cited said that the word subject to can really mean anything, and it's very difficult to pin it down. One case said that it means prone to and used the dictionary definitions. And so what you could say is, well, a defendant who's a first-time convicted under failure to register, who's a level 2, level 3, is prone to a CPSL, but not necessarily, because he's not going to be punished by it. It's not a set punishment.
So subject to is not mandatory. That's your bottom line.
Exactly.
So
Right.
So what was the agreed upon disposition here? That he would be subject to CPSL?
It was not part of the plea agreement. I know that the Commonwealth in the post-conviction hearing said, oh, it was part of the plea agreement. Well, there was no written plea agreement. There was nothing that was explained at the plea hearing that this is part of the plea agreement. Was explained is we charge him as a level 2. We charge him as a first offense, failure to register. He'll plead to, I think I just misspoke. He was charged as a second offense, failure to register. He'll plead to first offense in return for 1-year house correction. Okay, so the Commonwealth got the benefit of a plea, and
he would be subject to lifetime parole. That's what they said to the judge. He would be subject to lifetime parole.
As an aside, but not that. See, the Commonwealth is speaking out of both sides of its mouth and did at the post-conviction hearing.
What does defense counsel say about this? So was defense counsel at the time, what was defense counsel's understanding of the terms?
The defense counsel had very little understanding, as the court can see from the first attempted plea. There was a first attempted plea about a month or so before, and it's the first few pages of the hearing. And the Commonwealth said we're going to have a plea, and the judge said, oh, the clerk just told me he has to be sentenced to CPSL, and the prosecutor said, well, yes, he does. And the defense attorney says, well, I don't really know. I don't really know what's required in order to impose it. I don't know what's required in order to indict for it. I don't know, and I never spoke to my client about it.
But then you did.
Well, we don't know what he said, and to assume, I would think it's risky to assume that particular attorney then all of a sudden became a different attorney and fully informed his client. What we do know is that there was not a discussion of whether it was permissive or mandatory. And so when the Commonwealth stated, oh, it was part of the plea agreement that he be punished by CPSL, at the other side of her mouth, she's saying it was always going to be mandatory. We never discussed it was going to be permissive. Regardless of whether he's charged as a first offender or a second offense, it has to be mandatory. So then how could he have made a concession as part of the plea agreement, oh, I'll be subject to CPSL as long as you give me a first offense, because that wasn't a bargaining chip.
So if you prevail, what happens?
That it goes back for a hearing in front of the judge so he could use his discretion on whether to impose it.
So the judge would still be able to say, if you win, that I have the discretion and I decide to exercise it to do it or to not do it.
Right.
But he still may ultimately get it.
Right. And I think a great example of why the statute should be interpreted as it is and what happens when a judge does use his or her discretion is one of the district court written decisions that's included in the record appendix. It was the second example. It was a defendant who undeniably had properly registered as a sex offender ever since the obligation was imposed, had committed no new crimes, moved from one town in Massachusetts to another town, immediately registered in the new town, but failed to, 10 days before he moved, tell the previous town he'd been living in, that he'd always been properly registered in, that he was moving. And he was prosecuted, and he did a quaff, and the judge then was told by the prosecutor, you must impose CPSL, and the defense attorney says, no, it's discretionary, and the judge says, for someone like this, and in fact, she adds the fact that in the meantime, the defendant obviously had petitioned to SORB to be relieved of his obligation to register, and he was relieved of his obligation to register, which showed how little threat he was. And yet, if this statute is read for a first offender who could be caught in such a minor slip-up and still suffer CPSL, the judge would have no discretion, and he'd have to for the rest of his life.
But it was quaffed, right?
Yes, but the statute says that even if it's a quaff, you still have to be subject to CPSL for failure to register. They don't exempt a quaff. Yeah.
But just to be clear, the fact that the judge did not declare the CPSL sentence at the time of sentencing, you do not claim bars resentencing.
Oh, exactly. Well, exactly. It just
Goes back to see whether the judge is going to exercise his or her discretion or not.
Right. If you just go with the first argument, the second argument is because it violated the Fifth and Sixth Amendment because he was not present during when the sentence of CPSL was imposed, that it should just be vacated.
Okay, but you're not saying that the sentence has already been done, it's final, he didn't impose it, therefore the government is barred from going back to ask for it. That's not your argument.
Well, on the second one, I certainly cite the case law that says that what you do is you just wipe out that part of the sentence. And if I didn't say it clearly enough, I'll say it clearly now. I mean,
that's why I'm asking you.
Right.
If you prevail, are you saying the result is that he gets resentenced, or are you saying the result is because the judge failed to mention it at the time that that's the sentence and it's over and there's no resentencing?
Exactly. If you find for the second argument and that there is no reason that it's waived or whatever, that he cannot be sentenced to it.
Can't? Why?
Because for the second argument, that he wasn't present in an open court when the sentence was imposed. And according to the federal case law, where the analogy is either parole or supervised release, when the sentence of parole or supervised release is added to a docket after the hearing, that is a violation of the Fifth Amendment right to be present and the Sixth Amendment right and public hearings and counsel, that addition is void, and that what holds is whatever is orally pronounced. And that is pretty much uniform.
But if the judge believed it to be mandatory, which apparently he did, as did everybody else, why is the judge obliged then to announce every mandatory provision? There could be many mandatory provisions. Witness fee. I mean, there could be a whole set of things that are mandatory. Are you saying if the judge fails to go through the litany that they're not imposed?
Yes. For a sentence that gives someone virtually a life sentence, yes, it should be imposed orally in open court. And I think in this particular case, it shows why it's so important.
Wait a second. In this particular case, I'm sorry, everybody understood that this was going to be imposed. Everybody understood this was going to be imposed. That's apparent. Now, they may have misunderstood as to whether it was mandatory, but I don't think there was any misunderstanding by any of the parties. So this is not really a conflicting later imposed sentence. It's quite consistent with what went on in the court.
Yeah, we actually, one of the benefits of having it in open court here is because we know that the defendant, when the defense attorney tried to have him first plead, didn't know anything about CPSL. The lawyer admitted he never spoke to him about it. And if what happened at the second hearing happened at the first, the defendant wouldn't have known anything about it.
You might have an ineffective assistance of counsel claim. There's all kinds of claims you might have had. But on this record, I don't know how you can say that the defendant did not understand, nor his counsel understood precisely what the sentence would be.
I understand, which is why I distinguished it from a case in the federal court where it said, well, he knew as part of the written federal plea agreement that he was going to have 5 years of supervised release when orally the judge only imposed 3, and that the plea discussion said that his pre-sentence report said it. But in this case, the difference is that it was incorrect, that his understanding was incorrect, whereas in the federal case, 5 years supervised release was the only sentence he could get.
Okay.
Thank you.
Yes, sir.
Good morning. May it please the court. John Bossé for the Commonwealth, Berkshire District. The Commonwealth respectfully requests that this court affirm the Superior Court judge's imposition of community parole supervision for life, for the reason being that under subsection A3 of Chapter 6, Section 178H, the community parole supervision for life is mandatory. And it's mandatory because of the language shall be subject to. Shall means mandatory based
But we've said shall doesn't necessarily mean that in other contexts, in other sentencing contexts, haven't we?
Well, based upon law from other jurisdictions, the Commonwealth believes that shall be subject to imposes a mandatory condition. For example, we cite 2 cases from outside Massachusetts, the first being Westrock versus the Commissioner of Revenue, Director of Revenue, in which the appeals court from Missouri stated that in that case, the Director of Revenue from the state of Missouri had no discretion on whether to impose a tax, where it said the offender shall...
But isn't the issue the intent of the legislature, and can't we view this in the context of the earlier 2 provisions where they apparently, they saw that language, they even had the proposal, and they apparently affirmatively chose not to use the language which clearly would say shall be punished by?
I agree, Justice Gantz, in the sense that ideally it would have been nice if they did use the same language, but the fact that they didn't doesn't necessarily mean that they intended it to be discretionary.
But what if it makes, when you add the fact that they changed the language and you've got Section 2, which becomes superfluous? Right.
Well, in my opinion, I don't believe Section 2 is wasteful, because Section 2 applies to a failure to register second offender. It carries a different penalty than under Section A1 and A3. Ideally,
a different sentence of imprisonment.
Correct. Ideally, I guess they could have included it within A1, so not add A3, included it within A1, but they didn't. And I truly believe that we learned, the legislative learned a lesson from the Pagan case, because the problem with the statutes in Pagan was it didn't list out the facts that had to be proven in order to impose community parole supervision and who had the burden of proof. So if the legislative intended for the community parole supervision to be discretionary, I think they would have learned from Pagan and actually laid out factors for a judge to consider whether to impose community parole supervision for life. The fact that they didn't, we're left with the language shall be subject to, and that the judge has to impose it.
Did your complaint here specifically allege that he was a level 2 or 3 offender?
It did. Your Honor, if you look at the indictment, which is included in the record appendix, it did include it, Record Appendix 3. It said that he...
I see. Further being a level 3 sex offender. Okay,
correct.
So it was alleged.
Yes.
So you're not barred if it is mandatory from that.
Right. And I think the indictment language, the fact that we allege that he was a sex offender, he failed to notify the board of a change of address, and he was a level 3,
right,
allows us to allow the court to impose it.
Now, going back to the use of the word shall, I mean, if if the defendant is right, he still shall be subject to, he still faces, every person who is level 2 or 3 still faces the possibility. I mean, why can't shall mean invariably? That every person who's a level 2 or 3 offender invariably knows that they face the possibility of being given a lifetime community parole, and therefore they shall be subject to that.
I believe that the legislative so many times throughout criminal statutes use may and shall, and so I truly believe that the legislative, when they use the word shall, knew what they were doing, and if they really wanted to make it discretionary, like in so many other criminal statutes, they would have used the word may. For example, this court in Paquette analyzed the bail statute compared to against the dangerousness statute, and they said that if an individual under 58 is released on his recognizance, commits a new crime, Commonwealth moves to revoke bail. If the judge finds that there's conditions of release that may not ensure the safety of the community, he may revoke bail, versus under 58A, if he finds there's no conditions of release that can ensure the safety of the community, he shall detain the defendant.
You found no, I mean, I know there's legislative history in the sense that in the process it changed, but is there anything in the House or Senate journals or anything that has anything to indicate why it was changed?
That's a good question, and to be honest, Justice Botsford, I just didn't, my research didn't go that far, and I wish it did.
Okay, okay. So all we know at the moment is that in that process it did change.
Correct. Okay. Yeah. And with regard to the second issue, the Commonwealth believes that the defendant is now reneging on the plea agreement. Page 5 of the plea transcript, as well as page 8, are relevant because when, well, I should back up. When they first came into court on June 24th for a change of plea, the issue of community parole supervision got brought up, and the defense attorney at the time said, Your Honor, I need a moment to speak to my client about it. 3 weeks later, July 14th, they come in for a second change for the change of the plea, and the judge inquired about what was the plea agreement. The Commonwealth laid out that he's charged as a second offender. We're reducing it to a first, an agreement that he serves 1 year to the House of Correction and be subject to the community parole. And then the Judge Agostini asked the defense attorneys, is that your understanding? And he said yes. And then on page 8, he asked the defendant if he heard the joint recommendation, and the defendant said yes. So the Commonwealth believes it is clear that the defendant was put on notice that he would be subject to the community parole supervision for life.
If you go to the actual July 14th plea,
right,
Mr. Shelby, when the judge asked what is the agreement, which is on page 26 of the record appendix, he says the defendant serves 1 year to the Berkshire County House of Correction, that the Commonwealth should be reducing the charge under 178H to be a first offense, but it would be under the provisions of Paren 3, which would still provide for lifetime parole.
Right.
So it would provide, does provide for lifetime parole. It doesn't say mandate. I mean, are you saying that we can infer from that there was an agreement that he get mandatory lifetime parole, or that he get lifetime parole, as opposed to that he would be under the provisions of Parent? I mean, that's not an agreement. That's a fact. He would still be under Parent 3. In
the sentencing, when the defense asked to vacate the sentence, in the sentencing plea transcript, in the sentencing transcript, the ADA for the Commonwealth made it clear that she never spoke to the defense attorney whether or not it was mandatory or discretionary. It was just simply part of the plea agreement.
Right, but if the understanding was that it was mandatory, if that understanding hypothetically were incorrect, doesn't that, it's sort of like it's an agreement that may be voidable because it's based on mutual mistake?
I don't see it that way. I don't believe that the parties. I really don't know what the defense attorney was thinking as well as his client, other than the fact that it was going to be part of the agreement in exchange for not serving 5 years in state prison. He only served 1 year to the House of Correction. And I think the ADA interpreted the statute to mean mandatory because of the shall be subject to
No,
language.
I think everybody did. I mean, that's
Okay.
that's why we're here, right? I mean,
Right, yeah.
everybody. Yeah.
Okay.
And I take it at the end of the plea, the defense counsel says, well, he's going to be subjected to lifetime community parole now, and we have concerns about his ability to pay for GPS monitoring, and all of this discussion certainly makes it, to me, apparent that everybody understood, maybe wrongly, but everybody understood that this would be imposed.
I would agree, Justice Corday, and I also included that as part of my argument that the defense counsel, as you acknowledge, at his at the defense request, advocated for the waiver of the fees.
Mm-hmm.
Unless the court has any further questions, the Commonwealth would rest on its brief.
Thank you.
Thank you.